Thank you, Jocelyn. My name is Amy White. I am General Counsel with the West Ada School District, and I'm also a partner at the law firm of Anderson, Julian, and Hall. And I've spent about 30 plus years, we won't tell you exactly how many anymore, dealing with specialization of education law. So with that, Jocelyn, do you want us to just dive into this today?
Yes.
Okay, well, first of all, just our general disclosures that today is not intended to be, nor is it to create it's not intended to be legal advice, nor does it create an attorney-client relationship between myself, any of the districts or participants, whether it's in the West Ada General Counsel status or between myself and you and Anderson, Julian. And next slide, go ahead, Jocelyn. Our learning objectives today for at least my part of the process is we're going to review the requirements of Idaho law regarding parental rights in the school setting, because there's been some significant changes in the last 2 years. And that is going to include, and an important component is going to be the exceptions to to those statutes with regard to parental permissions in an emergency type of setting. So Jocelyn, if you could go to the next slide, I'm going to start at the 60,000 view. The first statute that I put before you in the subsections of that statute are 33512, subsection 4, 7, and 11. These are the components of Idaho code that provide for public school districts and public charter schools to have powers and duties with regard to the health of pupils. So it is these statutes and the subsections to the statute that creates the right of the board in establishing a healthcare services program, requiring it to protect the health and morals of the pupils. It does include the component of subsection 7 relating to the exclusion of certain students. Quite frankly, this was the COVID paragraph that provided schools great latitude with regard to making its own decisions during our COVID era as far as what they could and could not do, separate and apart from any other governmental or state agency. And then subsection 11 is the provision that provides that school boards can exclude and provide for the removal of individuals who are detrimental to the health and safety of students. And by the way, if you do such, if somebody is in a state where they are creating a detriment to the health and safety of pupils, it is a misdemeanor. So it's upon that big statutory powers and duties. In this subsection, by the way, I believe it currently has 17 different powers and duties for school districts. These are the 3 that just primarily relate to health and safety. They're things that school nurses and school administrators utilize in those areas, and they are the things that create the obligations and the powers that you as school nurses and that the district in general has to address those areas. Now, Jocelyn, if you go to the next slide. The next slide is Idaho Code 336001. Idaho Code 336001 has existed for a number of years. In 2023, so not this most recent legislative session, but the prior legislative session, there was a substantial amount of modification to the statute. And that modification addressed issues associated with consents and the legal obligations of school districts in that regard, as well as a number of other matters that emphasize parental rights in the educational setting. So even though we've got a formatting issue in the way that this has popped up here, the highlights are in red. So it is sections that relate to nursing and healthcare. So it's D, E, and F. So D is the public school's responsibility for notifying a student's parents or legal guardian regarding known changes and the student's mental, emotional, or physical health or well-being. So this created an affirmative obligation for every school employee, including school nurses and school administrators, to have contact with parents when you have a known change of the student's mental, emotional, or physical health or well-being. Well, in the nursing context, pretty much anytime a kid's coming to see you, unless it is treatment for an ongoing situation, you have knowledge that triggers that reporting obligation. There has been some detail provided from the State Department of Education on this of one, it has to be a known change. So one, you have to know about it. So a student's going to have to come in and talk to you about it. The second part is it actually has to be a change. So if you already have knowledge of a certain medical condition of a student and the student is coming to visit you in that regard, that isn't necessarily a known change that is going to trip the obligation. The State Department of Education has also talked about that it needs to be a sustained change. This isn't just one day I feel this way, another day I feel a different way. So it's a known, sustained, ongoing change that triggers that emotional, mental, or physical health or well-being that creates a reporting obligation on the part of school nurses with parents. Subsection E is a fundamental component of the entire thing, that we have an obligation to reinforce the fundamental rights and responsibilities of parents as the primary stakeholders to make decisions regarding the control and upbringing of a child. Well, in an educational setting, that's obvious, the engagement and interaction between the school's personnel and the parents. And that is also then going to include in the nursing component, as is tied to D, you notifying them of those known changes, the consistent and persistent changes. And then subsection F, that we are to encourage students to engage in discussions with their parents or guardians with regard to issues relating to their well-being. And if a student is less than inclined to do that, that the district participate in a facilitation of such discussions. That has been handled differently by each school district who looks at the situation, and quite frankly, it depends upon the staff and the abilities of the staff. Many school districts have decided that those conversations are going to be driven by engagement between the administration and the parent, where a counselor or nursing personnel may be involved. Some other districts with very strong programs in either nursing and or counseling have delegated that facilitation down to those levels as well. So that's something that you individual districts are going to have to address and have to decide. Now, if you'd move to the next slide, Jocelyn. This is the remainder of the sections that we are not allowed to have a policy that prohibits a parent from seeking and reviewing their child's health records. Well, that's kind of a pretty big given under Idaho law, as well as federal law with regard to a parent's right to access the educational and healthcare records of a student. Unless, of course, it is documentation regarding the abuse, abandonment, or neglect by the parent or legal guardian. And there is a time limit in that statute that they are enabled to access those records within 5 days. We are not allowed as a school district to adopt policies that prohibit school employees from talking with a parent about students' mental, emotional, or physical health or well-being. So that's essentially an inverse of the earlier subsection about advising a parent as to known changes regarding a student's mental, emotional, or physical health or well-being. They felt it needed a belt and suspenders, so they covered it twice in each direction. It's subsection number 5 that I have in the darker burgundy. That is the subsection that unfortunately appeared to get lost, and or it's also a very, very heavy lift. So at the commencement of not this 2004-2005 school year, but in 2003-2004, school districts were responsible for doing number 5. That they were to notify parents and legal guardians of the health services offered or made available through the school, whether that's provided by the school or whether that's provided by a contracted agency, a private agency, somebody that comes in and provides voluntary services in any context, including preventative health and wellness services, screening, medication administration, first aid and emergency care, and appropriate management of all health conditions. So that was one big step, is, all of that disclosure. The part of the sentence that also got lost was with parental consent. So at that point in time, starting at that latest period of time, all school districts were to notify every parent of what services were available and were provided, regardless of who was providing it, and that they were only to be provided with parental consent. So at that point in time, as of last school year, we were to be notifying parents. What's the best way to do that? Most school districts did it through registration documents, whatever your student information system was, and then obtaining those consents from parents, including things such as first aid. Again, the parental consent in there did not waive the right to see of the parents to see medical records, so that is a duplication of subsection 3 above in that same statute. Now, Jocelyn, if you just switch real fast to the next slide, and I'll cover the last thing in this, and I'll slide into how number 5 became such an issue this school year. So number 7 is another one of those that tangentially hits upon nursing and healthcare services in the school setting, and it relates to school surveys. So before any public school employee administers any non-curricular related student survey or well-being questionnaire or health screening to any student, there's a process that has to be followed. First, they have to obtain permission from the school superintendent or designee. Again, that is up to each individual school district to decide who that is, whether it's a superintendent or designee. And then the second part of this subsection addresses a number of very specific components of various surveys or screeners. So if your survey, questionnaire, or screener addresses the specifically enumerated items in that statute, so if it's the student's sex, sexuality, religion, personal political beliefs, mental or psychological problems, personal family information, or individual family financial information, prior to giving the survey has to be provided to the parent or legal guardian of the students in question, and they have to approve it. Here in West Ada, you can imagine if you're tracking down 40,000 of these, it's a nightmare. So the practical outcome of that for our district is, quite frankly, there are no surveys, well-being questionnaires, or health screenings that are being done because it is simply a logistical impossibility. This is why we've had so many problems with the suicide screeners and those types of things, just even collecting statistical data on school-age students around the state on various healthcare issues, suicide included. I don't think that was necessarily what they intended when they wrote this, but it is certainly broad enough to cover those. I'm not saying legally it can't be done. Of course, it can be done the way that statute is written. It's just from a practical standpoint, it is a logistical issue. I have seen individual classes where a class will do it, or an individual project where you're better able to control the numbers. You're better able to track that they've been sent out, that you have received responses, etc. Now, at the very bottom of the section, it talks about the fact that if we fail to follow these, we being a school district, they can file a complaint with the school, and eventually they can go ahead and sue the school district for monetary damages, as well as an injunction to prevent the schools from engaging in this conduct. So this statute, in the format that I discussed with you, existed as of 23-24 school year. Now, Jocelyn, if you switch to the next slide, this is Idaho Code 32-1015. This is part of the Domestic Relations Code as opposed to the Education Code. This statute came into being, or the amendments to this statute came into being for the 24-25 school year. So this school year in question is when this became more directed. It's very specific. It's more publicized. It's more well-known with regard to the parent setting as well as the education setting. So again, I have only put up there the critical components of this. Again, repeating that parents have the fundamental right to make the decisions concerning and furnishing healthcare services to their child. So it is a more specific version of the fundamental decision maker subsection clause in the Parental Rights Act that we just reviewed. And then number 3 is, and number 4, where it really hits into the nursing situation or the healthcare services of a school district, that except as otherwise provided by court order, and in all honesty, I have not yet seen one that has a court order that provides for this. An individual shall not furnish healthcare services or solicit or furnish healthcare services to a minor without obtaining the prior consent of the minor child's parent. So this is where it is indicating that healthcare services in a school setting, nursing services in a school setting cannot be provided without parental consent. If you go back and think of Idaho Code 33-6001 that was adopted the year prior, it is effectively saying the same thing, because we had to provide them notice of all the services that we provide with parental consent. So we couldn't be providing those services in 33-6001 without parental consent to begin with. Now they have really solidified that in the Domestic Relations Code. I'm not sure why we needed this twice, but we have it twice. So we must obtain the prior consent of the minor child's parent prior to providing these services. Now, a number of states have adopted something similar that requires that consent to be in writing. Idaho does not have that. However, just as a best practice, I would recommend that when you're obtaining that consent from a parent, Whether you do it in the subsections we're going to talk about, or if you're going to pick up the phone and give them a call, that you make sure that you have some sort of a written track record, whether that is a written confirmation back to the parent, an email indicating back as per our discussion on whatever date you provided us consent to do, just to protect the school district, to protect you in the health services department, just to indicate that we have obtained that consent. Now, subsection 4 does allow in the school setting the provision of these healthcare services under 3 different exceptions. The first exception is subsection A, that the parent of the minor child, and quite frankly, it'll be parent or legal guardian, has given a blanket consent authorizing the healthcare provider to furnish the healthcare services. So if we look at that in relation to Idaho Code 33-6001, where we had to disclose what we provide with parental consent, the easiest and probably best practice in doing this is, again, to do it in the student information system. We disclose as a school what services we provide, whether it's us directly or indirectly, and then we obtain that consent from the parent. I've had Tracey do some tracking down on our consents here at the district, and I just went pre-K through 3rd grade, 4th grade, she's telling me. And it was 1.5%, 2% that had not consented. Yeah, there was a percentage that hadn't answered the question, and we're working on that. But those who actually did address the question, it was an extremely high percentage who understood the need to do that consent. So if hopefully statewide, it's very similar to what we're seeing, that takes care of the majority of the issues. Then the healthcare services department can provide those services to students under that exception. I would make sure it's one of those things that we have disclosed under 33-6001. Hopefully you've written that broad enough to cover it. There are 2 other exceptions. So say you haven't done that as a district, or say the parent has said no. The healthcare provider can reasonably determine that there is a medical emergency. And then in that medical emergency, they have 2 different options. If we have a child who is facing a situation where death is imminent or irreparable physical injury to the minor child is going to occur, there is an exception that allows for the provision of healthcare services. There is no definition in this code as to what any of those terms mean. So preventing death or imminent irreparable physical injury, you are going to use your medical judgment and your experience to make that determination. The second exception is also an emergency exception, that if after a reasonable diligent effort to contact the parent or legal guardian and you have not been able to locate or communicate with them, and if the child's life or health would be seriously endangered by a further delay in furnishing of healthcare services can be provided by the school district, even if there has not been consent. Now, as a practical matter, we also know you're probably calling 911 and getting EMS there. And quite frankly, if you aren't, you probably haven't met either of those 2 exceptions, because it's not going to fall into the emergency setting. So do know that 1 and 2 are separate. It's either 1 or 2. And 2 has 2 different subsections to it. First being that you've attempted the communication and failed, and the minor child's health or a life would be seriously endangered by a further delay. So that is how these 2 statutes sort of interplay and overlap with each other. The obligation to provide notice and consent has existed for 2 school years now. It's just that first school year, I'm not sure how well that message got out, and or was it buried in a ton of other stuff that was included in Idaho Code 3000 or 33-6001. Now, Jocelyn, if you flip to the next slide, I just have the definitions in there for this code section of 32-1015. You as basically anyone who is providing healthcare services in a school setting. So it is somebody individually licensed or certified to perform healthcare services or provide counseling consistent with state law, or any agent or third-party representative. So if we're contracting out our nursing services, it's going to fall within the definition of the healthcare provider under the statute. And they have also diagnosed healthcare services. It's extremely broad. It's very similar in application to what exists in Idaho Code 33-6001. So the diagnosis, screening, examination, prevention, treatment, cure, care or relief of any physical or mental health condition. Well, that probably is covering everything that a school nurse does every single day, including illness, injury, defect, or disease. I just also had bolded the health information just because of the next slide also has language in it. So if Jocelyn goes to that next slide, this statute also requires a school district, again, similar to 33-6001, to not deny, to make sure a parent has access to health information contained in our school records, our school health records. We can't deny that unless there is a court order. And there are the exceptions, obviously, if it's prohibited by a court order or if they are subject to an investigation relating to a crime committed. So again, that's going to be the abuse, abandonment, neglect type of standard that we have in the companion education code. Now, I do know that there is some movement to get some of these changed in the next legislative session. And I have had conversation with both school districts as well as lobbyists and educational organizations that if you change one, we're not going to get what is needed, that we need to change both. From what I am understanding from legislators I have communicated with, this ended up being far broader and far more limiting to schools than was the intention, because they covered so much, basically anything that is involved in the healthcare office with regard to a school. Now, the next slide, Jocelyn, it just indicates that this is a continuation of the domestic code, just simply that this does not in any way condone abuse, abandonment, neglect. So those statutes still exist. Our mandatory reporting still exists. In no way does this change or condone mercy killing, assisted suicide, those types of things. So any parent who is involved in those abuse, abandonment, neglect statutes are still going to have those controlling statutes that overlie them. This statute also then creates a private right of action for our parents. So what that means is if we as a school district violate the provisions, if we provide services without consent and or are not meeting the standards in the three specifically enumerated exceptions, they can go ahead and sue the school district for monetary damages and for an injunction to stop the school district from engaging in those types of healthcare. Like I said, I've heard from various Idaho government stakeholders who have commented to the effect that this isn't what we intended. Oh, don't worry, you're not going to get sued. And I always respond back, I know it's not what you intended. And I also know you're not the one who will be sued. It would be the school district who ends up getting sued. The last statute I put in here today is just the basis for a lot of this. This statute has existed for some period of time. And Jocelyn, if you'll go to the next slide, it's 32-1010. Again, this is in the domestic relations law. And this is what gives parents the right in general, again, to direct the upbringing and care of their children. We've now seen this in 3 separate statutes, 3 different versions of the same intent and the same language, that it is the parent's fundamental right to direct their children's destiny, upbringing, and education. So again, it's intermixing the 2 different titles, Title 32 in domestic relations and Title 33 in education, putting the parent's decision-making and the parent's control as paramount. And as you see in number 6, that if the government, we as school districts are the government, if we engage in efforts that restrict or interfere with those parental rights, it is the strictest scrutiny for constitutional standards. What that means is that if we as a district are in any way preventing a parent from engaging in the ability to control their child's health care activities at school, if we're violating the consents, if we're not clear and obvious about those consents, the scrutiny for which a school district will be examined in court is the highest level that can happen in a constitutional analysis. Very, very difficult for a school to overcome. So we need to dot our I's and cross our T's in making sure that we've covered the consents. And as I'd indicated, if we don't use that blanket consent that the statute provides, you can still do an individual consent, but I would make sure that it is documented. So if you have a student who has not either filled out the questionnaire for consents and or has said no, and you've got a situation that falls short of that life-threatening or life-altering emergency situation, There's nothing that prevents you from picking up the phone, calling the parent or legal guardian, obtaining consent to provide healthcare services under those various definitions. Just from the legal perspective, I would prefer if you had somebody who witnessed that conversation. If not, I understand those things happen and we have limited staff. I would do a confirming email or confirming communication, text message, whatever, back to that parent. You know, as discussed on whatever day, we talked about your child's injury. You gave me consent to do X, Y, and Z. I went ahead and did X, Y, and Z. If you have any questions, follow up. I would also document that conversation and the action that you took in providing healthcare services in whatever student records your healthcare program at your school district utilizes, so that we have a very clean track record of everything that was done, all the consents, and what you as a healthcare professional did to address those. So just the key points as I'm going to finish up on those, making sure that you've got parental notice and involvement in decision making. The parental consents are required absent those two emergency situations, because the third exception is a blanket consent. And the third, that this is likely to change again during the next legislative session. I do anticipate that some component of this will remain in place and that we will still have to get consents and or still have to provide notification to parents of the services we provide. However, I think it's highly likely that either the definition of emergency services will be expanded, or the types of healthcare services that the Health Services Department provides to students that require notice and or consent may be limited. And with that, I just have the last slide that identifies those statutes that we utilized again. And I'm going to slide over and let Tracey slide in here and let her pick up from there.
Thank you, Amy. And just so that we can get through our slides, if you have questions, please put those in the chat. And we can answer them in the chat. Also, Amy will be back in May to give another update. So we can look forward to having her come back. Okay, so now we'll pass it on to Tracey. Thank you, Amy.
Thank you, Jocelyn.
Thank you, Jocelyn. So now we're going to talk about the role of the school nurse and in particular delegation and monitoring. So next slide. Our learning objectives today. We'll talk about school nursing care, how it functions as a solo healthcare provider in the school setting and rarely has physician oversight. We'll talk about and understand, or hopefully you'll understand the role of the school nurse within the context of Board of Nursing with regards to statutes, rules, and guidance. We'll talk about the school nursing scope and standards of practice, and then we'll talk about case management versus walk-in traffic. And I'm going to flip these learning objectives, and we're kind of going to start in the weeds and start with the case management. A lot of people think that school nursing actually is a simple practice of nursing, that we tend to the walk-in needs of students into the health office. It actually is a very complex specialty within the realm of nursing. That school nurses need to have fundamentally the knowledge and understanding of the disease process, the pathophysiology of medications, the understanding of the medications and how they work, but then being able to apply it in the school setting with the intent and hope to improve the students' access to education. So we should be enhancing and increasing instructional time, not becoming the excuse or the barrier for instruction time. So let me tell you and give you a couple of examples of that. When we are treating the student with diabetes, are we ensuring that we are scheduling their treatments for most of the time outside of the PRN needs? Are we scheduling those intentionally so that they're not missing instructional time? Are we working with our health providers to ensure that students' underlying medical conditions are well managed? If they have migraines, are they managed so that they're able to attend school and their instruction rather than waiving attendance so they're not at school? We're the barrier. We're waiving the attendance. We're not providing access to education. More complex is our kids with mental health conditions, and I want to talk about those. Case in point, we have a student who's entering 10th grade. He's been diagnosed with a traumatic brain injury due to a significant car accident when he was younger. He's currently on medications. One of those medications is a stimulant. The other medication is for bipolar disorder. Suspected that it's due to his poor impulse because of the TBI. So the prescription's written to be given TID, which we know should be given morning, after school, and in the evening. But we start to look at, why are we giving a stimulant to a student with a TBI in the morning, after school, and before bed? And could that be contributing to the reason why the kid's not sleeping? And because they're not sleeping, is that now why their poor impulse control and the behaviors are increasing? That's the case management side of it. Why are we giving bipolar meds to an individual that's had a traumatic brain injury for poor impulse control? Is that the right med? And so we should be having that understanding and collaboration with the physicians and the prescribing providers, so that we all understand why we're giving those meds, what they're there for to treat. And that's the case management piece of it. Not just, I got a kid who's on a med and I'm going to give the meds. There really should be a fundamental understanding why, what circumstances, is it treating the right condition? Do I understand the treatment of the condition? And then the other big one with mental health conditions that we're seeing a lot of is that pediatric kids are getting off-label use medications for treatments of mental health conditions. Do we understand that and recognize that it's an off-label drug? Do we have enough sufficient research? And should we be having those conversations with providers? Again, as to the why and the understanding of the why. So effectively, to remove the health, medical, mental barrier, rather than us being the barrier, are we collaborating? Are we intentionally delivering services? And are we mindfully scheduling routine treatments and procedures? Next slide, please. So I just gave you the overview of what a school nurse does from the case management side. So then the next thing, and we're getting higher up and out of the weeds, is, do we understand the scope and standards of practice? So I strongly recommend that you get this book if you don't already have it. It's which is the National School Nursing Association Scope and Standards of Practice. School nurses will continue to adapt their practices to an ever-changing world, and there must be greater alignment, integration, collaboration between the educational team and the healthcare team to improve each child's cognition, physical, social, and emotional development for successful learning outcomes. We just talked about case management, and now NASN goes into greater detail about that alignment and case management and the sophistication of it. So I strongly encourage, again, that you get the book and that you start looking at those scopes and standards of practice. Next slide, please. It's a great resource and easy read. Talks about standards in the sense of assessment. It's really important to note, and especially in special ed, and when we're delivering Medicaid and PCS services, that when we're talking about a nursing assessment, it's different than an educational assessment. And we have to have that fundamental clarity when we're having discussions with our educational team, that nursing, every student that we access, we do an assessment, and it's a nursing assessment. We have nursing diagnosis. What are our outcomes? What planning did we do? Did we implement the planning? And then we have subsets for coordination of care, health teaching and health promotion, and then our evaluation. Is the planning and the outcome identification working and effective? And if not, should we be doing something else? And again, I go back to the medications that we are handing out to kids. We really should have an understanding and be coordinating care with our healthcare providers and doing observations in the classroom setting of what's effective and what's not. Next slide. So I ask you or invite you to go to the Board of Nursing link, and I put the link here for your convenience. And I just want to walk you, you can go to this on your own computers if you would like. Next slide. So this is the landing page when you get to the Board of Nursing. And I want you to note in the bottom left-hand side, this is where you go to the statutes, rules, and guidance that govern the Board of Nursing. Next slide. And you just, it's really convenient, you click on that. So when you click on it, this is the first thing that's going to pop up. It's going to pop up with the statutes. In particular, our statute is the Nursing Practice Act, which is chapter 14. So I drew an arrow, that's what it's going to look like. You're going to click on that link. Next slide. I'm pretending that we're clicking on the links, but you can be doing it on your own device. This is blurry and hard to see, but I just wanted you to know this is what you're going to get to. And you can see when you look at this, that the statutes refer to what is the Board of Nursing, what are their duties in their jurisdiction, what's the definition of a nursing education program, certified medication assistant, certified nurse assistant, and then license renewal. Next slide. The next is under rules. So if you click under rules, IDAPA. And these are the rules of the Idaho Board of Nursing. And this is more like the meat and guts of what we do in school settings and what kind of latitude we have. So let's go to the rules. So we're clicking on IDAPA. And this is where school nurses, administrators can go and look at who does the rule apply to, what is the purpose of the rule, where you can get more information, but most importantly, the legal authority that we have to perform health functions. Next slide. Important definitions, I just put them in here, but you can go through assistant with medications, what that means, who's a charge nurse. Again, you're thinking at it through the lens of the school setting. What is an LPN? What's an RN? What are the practice standards? What does supervision mean? So next slide. So you'll find your definitions. Next, you will get to the section 200 after definitions, which talks about your practice standards. And I put the decision-making model for the licensed nurse about the scope of what they can do, in particular to delegation. That's always a big thing that comes up in education, is who can I delegate to, what can I delegate to, and what are the parameters. It's important to note, if you haven't already, that these rules changed on March 28th of 23. So before we had more proscript information in our practice standards. For example, it would say we cannot delegate trach care. Now, in the practice standards, it will say that there should be an evaluation of what we're delegating, the complexity of the care, and the ability of the individual to delegate that task to. So it gives us some latitude of saying, what are you going to delegate? Should you be delegating it based on the complexity of the care? Should you be delegating it based on the given setting? And then have you evaluated or assessed the person that you're delegating to? Next slide, please. Deciding to delegate, again, it talks about should you be delegating this, the licensure of the person, and the education that they have. And then it also, and I think this is key, is that the activities are consistent with your job descriptions and policies in the practice setting. So if you haven't done so already, I would strongly recommend that you look at your job descriptions of who can do what, but that you also have policies in place, process, procedure, medication administration that clearly outlines who can do what in the educational setting. Next. So these are some of the practice standards, and I put some stars by them. Consider the nature of the act, the complexity of the care needed, the degree of critical thinking required, and the predictability of the outcome of the act to be performed. Much different to delegate for someone to change a student than to consider a skilled nursing task, G-tube feeding, NG-tube feeding, trach care, G-tube. So you want to consider the complexity of the care, the degree of critical thinking, and the predictability of the outcome. The next thing is it talks about UAPs in the setting and delegating to UAPs. And again, the key here is that you should have something in writing, what you're going to delegate. Wake up, Randy. What you're going to delegate, the steps of the process and the procedure, and that you have return demonstration competency with the individual. And then the other thing that we really need to do a better job of is supervision and monitoring. So are you going back periodically to that person and observing them doing the G-tube feeding to make sure that they're following the proper steps and procedure? Next slide. So degree of supervision and monitoring, I think sometimes we lose that. We train, we delegate, we hand off. Are we following up throughout the year and periodically observing and monitoring the individual that we delegated the task to ensure that they're doing it appropriately? And then here's the last item with regards to making sure the person's competent and qualified. That's what I refer to and we refer to in health as the return demonstration competency. Next slide. So guidance, we're going back to the Board of Nursing, talks about these items. What I will tell you is that the statutes have remained pretty consistent. There haven't been many changes. As we just identified, the rules changed. Almost every rule changed in 328, 23, and were rewritten. The guidance, every time I click on the guidance page, there are additional items in here. And so I quickly take a look, see what's applicable, what's helpful. And what I've noticed is the practice policy has been helpful. So if we click to the next, I didn't copy that. I thought I did copy it, but I found that practice policy, it delineates our LPNs, CNAs, MAs a little bit more. So some common errors that we're just seeing in schools or some things that maybe we can improve upon. I really think it's collaboration with our medical community to make sure that our kids' underlying chronic conditions are well managed so that they can be at school in the classroom and are not losing loss or experiencing lost instruction time. That we're administering prescription meds, that we're doing it with complete and valid prescriptions and not at a parent description or a direction. So for example, making sure with insulin that we have some doctor's notes and orders and that the parent's not telling us in the morning what doses to give, what the sensitivity factor is, what the carb to insulin ratio or the basal. The Board of Pharmacy and the Board of Nursing says that comes from a valid prescription. So we have to be careful in the practice setting of the school and the education. The parent doesn't come in again. I just talked about insulin, but with a student's mental health meds, and it says to give 2.5 milligrams, and they say, I want you to give 5 so we can see what happens. I want you to give a half. And we all know that parents, we've experienced parents that have done that in the school setting. When parents provide training as to the specific treatment or procedure for their children, that we understand that they're providing us the training for their child. So G-tube feeding, parent comes in, shows us how they do the G-tube feeding for their child. We need to fundamentally be able to go back to our nursing training and our competency and what we know from administering G-tube feedings and making sure that they align and that they're safe. An example that recently came up is NG2 placement assessments. Before, you rarely, if ever, see an NG tube in the school setting. We are now starting to see NG tubes in the school setting. And we all know that before we administer anything through an NG tube, we should be checking placement, correct? So that we are not, what I understand is that some of the NG tubes that are being placed in PEDS are of a more rigid type and a narrower type, and they don't recommend that we check the NG tube placement, which is inconsistent with the nursing practice that we're currently receiving and that's currently out there. We need to make sure that we're getting a physician order for that, or a physician note saying what's the rationale and the reason that we're not following the nursing practice guidelines that we've been given. Make sure that you have written guidelines for your nursing practice. Make sure that you have written training protocols and that you're doing return demonstration competency with your UAPs. And then make sure that you have virtual platforms so you can supervise and monitor your UAPs throughout the school year as they do treatments, procedures, or administer meds. Next slide. So key points. I hope we're getting some clarity every year that we do this and understanding the role of the school nurse as the case manager with the underlying goal to improve overall academic success. That means giving kids and affording kids with chronic medical or mental conditions the same instruction time as their counterparts. That we understand and incorporate the importance of NASN scope and standards as the framework for guiding school nurse practice. That we understand the Board of Nursing statutes and rules governing nurse practice in the educational setting, especially when we don't have physician oversight. And in some of our rural settings, some of our nurses are individual practitioners. And that we use this information throughout the school year to provide the lens and framework for the upcoming Project Echo School Nurse educational sessions. And with that, I am done with six minutes.
Thank you, Tracey. Okay, so we
Thanks,
do have a few
Jocelyn.
minutes for questions. Feel free to unmute if you have a question. I'll just get quiet for a little bit and see if anyone. Doreen, go ahead.
Thank you, Tracey. That was a great overview. And I can't emphasize enough that you, as a school nurse, if you have a question, that you don't use a parent as the medium between communicating between you and the provider. That can sometimes get you in trouble.
Mm-hmm.
Never feel like you can't reach out to a provider, especially if it's subspecialist, like in the case of an NG tube, reaching out to that pediatric GI doc. That is part of your right to do, and don't feel like you're bothering us or them. It is critical because there's a lot of miscommunication, and it is important to get the parent's permission before you do so. But after parent permission, absolutely reach out to them. And I know I've worked with Tracey on some of these situations, and I think that's a critical point.
Thank you for emphasizing that. It's really important that we're involving physicians in the care of our kids. Thank you.
Thank you, Noreen. Randy, did you have anything you want to add?
I was just going to say, last year I had a student that we really were having a hard time communicating with this psychiatrist and getting some medication things, and it was really great. I called the psychiatrist, and since I was the superintendent, it was like, he gave me his cell phone number. He goes, if you ever have questions ever, you just don't even call my nurse, you just call my cell phone number. I was shocked, but it was really cool that it's like, yeah, we'll help you out whatever we can.
Thank you. I think these stories really help in making it more accessible when people have questions. Does anyone have any questions or other comments for our presenters or any of our panelists?
And Amy is here if anybody had any follow-up questions.
Yeah.
Yep. Oh,
Hi, this is Bonnie Hamilton over at Eagle Hills. I'm not sure if I need to turn on my video or not.
No need, you can just
Am I
ask.
okay without it? Okay, this is a question for Amy. I just want to make sure I understood correctly. When we call a parent who has not, they say no consent to treat, and we speak with them and they say, well, I just want you to give them an ice pack or something. We are allowed to do that as long as we document verbally. And then it sounds like she said also send an email to say what we reviewed. I just want to make sure I have that correct.
Yep.
Yeah.
Well, and one thing is you also need to take into consideration the rules of the organization.
Correct.
And at West Ada, we've said no verbal consents. What Amy's saying is you're getting the consent in writing and follow up.
Okay. Thank you for clarifying that, Tracey.
The other thing with that is when you have those situations, that also gives you the opportunity to engage in that educational discussion with a parent, that it would be a whole lot easier if they went in and changed the consent and or completed filling out the process, building that trust in that relationship so that they feel comfortable doing that.
Okay.
It's a
Great.
very small
Thank
number.
you.
Yeah, it is a very small number.
Yes.